legal body that settles disputes amongst states. It comprises of 15 judges, whom are elected for a period of 9 years. The International Criminal Court was established in 2002 by the Rome Statute of 1998. There are 18 judges, 4 from Africa. It's Nigeria, Botswana, Central African Republic, and Kenya. 22% of the court's budget is how much a single country can pay. This is, in fact, the most important part of my presentation, so if you will please allow me. More than 50% comes from the EU. The biggest contributors on record are Germany, UK, France, Italy, and Spain. I'm going to read a few lines from this book before I conclude on my presentation. If you add the total sum of the money that these countries give, if one then adds only MLSP of Canada, which paid X amount of euros, Australia, which paid X amount of euro, and I mean millions, New Zealand, white nations provide 69% of the budget of a court that is exclusively prosecuting black Africans. There is always a direct relationship between levels of payment and levels of control.
Sorry, I'm just curious, what does this have to do with our
I'm coming to it. I'm coming to it. Just let me
Question I also have.
Yeah.
I'm coming to it. I'm coming to it. How does this relate to R2P? See, I was thinking before you asked that question. Since the official endorsement of R2P by the United Nations in 2005, a robust enforcement of the document has followed, with preponderance of evidence pointing mainly to African countries. How does the R2P relate to the ICC? As of 2013, the court had initiated cases in 8 African countries: Uganda, DRC, CAR, Sudan, Kenya, Ivory Coast, Libya, and Mali. The ICC has charged 32 people to date. Out of the 8 countries forwarded to the court for prosecution of crimes against humanity, genocide, and violations of human rights, 5 countries mentioned forward were affected by R2P interventions. That answers your question, if I'm correct. Given the ambiguity of the Security Council's role on intervention with specific references to following articles of the UN Charter, Article 2.4, Article 2.7, Article 24, 39, and 53 undermines and brings to question the legitimacy of the R2P instrument. Recommendations. The UN must repeal and or give clarity on the language of its 1945 charter with regards to intervention, which have gained area of interpretations by individual member states, mostly Western and European, which might be followed by global anarchy. The expression, responsibility to protect, must always be redefined and given a definite definition that incorporates the ideals and interests of the African continent as equally as their non-African counterparts. The labyrinth of justice. Because the founding members of the UN are the same with permanent seats on the Security Council, who also are the biggest financial contributors to the ICC, by this construct of illegal precedents, justice will only be an idea expressed in words and a chimera. Therefore, the responsibility to change this medieval practice no longer lies with the UN or the divisive institution of international public law. The new order must be born free from injustice and partiality, and the consciousness of sovereign states must begin to articulate itself in a more nationalistic and self-determining manner. And in my own words, if you were to convince me that international law exists, begin by telling me that it does not, for the rule of law in itself is not the law that rules. Question and answer. Thank you.